morning, Your Honor. Emily Ward from Fenimore Craig on behalf of the plaintiff, D Kraft, who is present here today.
Good morning, Your Honor. This is Ryan Womack on behalf of defendants and counterclaimants.
All right, welcome to you all. We are here for oral argument on defendants, counterclaimants, motion for summary judgment. I've reviewed the parties' briefing and the fact statements, and obviously I'm new to the case. I went back and looked at Judge Moskowitz's ruling from February and the prior summary judgment briefing, as well as the cases and statutes that were cited in your briefing. I wanted to start by just giving you a few points that I'd like for each side to address. The first is really for both sides, and it's that there was a footnote dropped on page 2 of the response about the fact that ARS 524, was repealed in 2026, but then it wasn't developed in any way in the argument, and then the reply didn't address it. So I just wanted both parties to tell me whether or not there is any significance to, from your perspective, to the repeal that happened in 2026. For the defendants, I'll start with you. The one thing that also didn't come up, but I noticed in looking at your exhibits, your fact statement, is that the title, the recorded title of the Benedetti children, hopefully I'm pronouncing that correctly, the fact statement says that's established as of the August 10, 2016, when the beneficiary deed is recorded. But when I look at the beneficiary deed, it refers to becoming effective in the future on the death of the parents. And so I wanted to understand why the effective title date for recording purposes is the date of that beneficiary deed. Second, as far as the tax records that you submitted in support of the payment of taxes, that's represented as having as evidence that the Benedetti children paid taxes for 5 years, from 2016 to 2021. The statements, though, that you relied on aren't all addressed to the Benedetti children. I think at least a couple of them are addressed to the parents. And obviously, there's no indication of payment in the statements. Then one of the things the response pointed out is you can't come back and try and fix that in the reply because they're not establishing new facts. They're just telling you where the deficiency was. You then, in your reply, attached the printout from the assessor's website showing payment. But even if so number one, why should I consider that under Rule 56 as something permissible in response to new facts? And second, even if I did consider it, how does it establish, again, that the Benedetti children specifically paid those taxes? Because when I look at it, all it says is lockbox, or it says different sources of payments, but it doesn't identify the payors. For the plaintiffs, I'll ask you to address, one of the things that you raise is that Dominguez requires not only the recorded deed and payment of taxes, but also a claim of ownership. But one of the things they also both say, Dominguez and Quality Plastics, is that visual appropriation is not required. So what are you contending is required under 12-524 to establish the element of claimed ownership? And why is the record we have not sufficient to establish that? Second, my question is really, is there any dispute that the Benedetti kids paid those taxes from 2016 to 2021? And lastly, the term "lot," I think you're construing as fairly restrictive. Why isn't their claim sufficient when they are claiming title to the entire lot, which includes the portion of the driveway that your client claims an adverse possession right to? And why doesn't lot encompass that portion of the property? So those are kind of the points I thought I'd give you to focus on in your arguments. That way, hopefully I don't interrupt you too much during your argument. I may still, if I have a question pop into my head, and I promise it's not to be rude. It's just that I'm afraid I'll forget if I don't ask when I think of it. But I'm going to try to not to do that. So, Mr. Womack, this is your motion, so I'll let you begin.
Yes, thank you, Your Honor. And I appreciate that's actually really helpful the way that you do this to give us a heads up as to issues to address. So thank you for that. I'll try to, I'm going to talk about, I'll definitely include everything that you brought up in what I'm talking about. If I missed something, if you'll please let me know. Your Honor, summary judgment in this case should be granted for two reasons. One is that the Grosovs hold record title to the real property at issue, and that's not in dispute. And then number two, any interest claimed by Kraft, in this case, by typical adverse possession claims with exclusivity and so forth, which again we dispute that. But to the extent that that claim's even there, that was extinguished by August of 2021, consistent with ARS 12-524. Plaintiff, I did notice this was interesting. Plaintiff criticizes the length of our statement of facts in their response. But again, Your Honor, this motion for summary judgment is really a straightforward statute. It references a straightforward statute. It's a straightforward issue. We don't need a long statement of facts or even a long motion for summary judgment in this case. And I think the reason its brevity actually shows that it's a straightforward issue. That's the kind that courts grant summary judgment on. So to start with, just exactly why based on Arizona cases, why was ARS 12-524 enacted? And it's to address these types of attempted takings. It requires an individual who's a record title holder, the property's in the city limits, there's claimed ownership, and they're paying city taxes for 5 years. Under that instance, very straightforward, Arizona provides clear title. Is it possible, Your Honor, for me to share my screen? I was gonna show some of the case law that we're relying on. I'd like to put that up on the screen. Is that possible?
Yes, I just made you a presenter, so there should now be a button that says share up at the top right-hand corner.
Okay, thank you. Let me pull this up.
And by the way, if you see me looking over, it's because I have my notes on a different screen and I might be typing here and there.
No, I understand. Okay, Your Honor, is my screen showing? I can't really tell from here. Okay.
It is.
Wonderful. So under the Sparks case, which again, this is a case that both we cited and plaintiffs also cited in their brief. And it says, and it's referring to, at that time, 12-524 wasn't in existence as it's stated now, but the courts and the cases that we've cited, it references, it said it's basically identical at that time. And you'll see that, Your Honor, but it says the purpose of the law is quite obvious. Such enactments are invented for the purpose of quieting the title to city lots and putting an end to litigation. And neither the power of the legislature to do so nor the wisdom of so doing is